Thank you very much, Presiding Officer. The Cabinet Secretary has covered much of the background and timescales to this supplementary legislative consent memorandum, so I shall focus my remarks on the three areas covered by my committee's report, Constitution Europe, External Affairs and Culture Committee. The sunset, revocation schedule and preservation powers, the second being the powers to restate, revoke, replace, update retained EU law, and thirdly, the reporting requirements. The removal of the automatic sunset addresses the concerns that we had with regards to the cliff edge of that clause. Instead, only rules specified in Schedule 1 shall now be attached to the bill will be revoked at the end of this year. As the Cabinet Secretary has outlined, it provides 587 instruments that are to be revoked, and the Scottish Government suggests that 148 of these instruments impact on devolved areas. And the Government has also stated it considers that 9 cannot yet be said to be obsolete and therefore opposes the sunset as laid out by the Cabinet Secretary. As convener of the Constitution Europe, External Affairs and Culture Committee, I have written to the relevant subject committees highlighting the timescales for possible removal of instruments from the schedule. And we have noted concerns expressed by Environment Standards Scotland, who wrote to us on Monday to draw attention to 2 out of these 9 instruments, noting that, quote, based on some of our current analytical work on air quality, standards and targets in Scotland. We have shared their correspondence with the Net Zero Energy and Transport Committee. But there is also a wider issue here, one that concerns the complexity of how devolution is operating outside of the EU. The committee considers that the common frameworks were the agreed process by which governments should work together to provide clarity, certainty and in delivering an effective regulatory environment, and in doing so respecting the devolution settlement. But the UK Government does not appear to have consulted with the Scottish Government on the amendments it tabled on the 10th of May 2023, or to explain the extent to which they impacted on devolved competence. The committee will be writing to Kemi Badenoch, the UK Minister in charge of the bill, asking why this appears to be the case, and in particular in relation to the instruments in Schedule 1, which at least in part fall within devolved competence. The committee has previously found that the Seoul Convention to be under strain, and the Cabinet Secretary gave the examples of and how often this has happened since the UK's departure from the EU. So we have previously written to both the Scottish and UK governments for their views on whether they agree the Seoul Convention is under strain, and whether and how it could be strengthened in law and be subject to judicial review, or whether and how it can be strengthened in a non-statutory basis. If I could turn now to the powers to restate, revoke, replace and update rule. The Scottish Parliament ought to be able to effectively scrutinise the exercise of all legislative powers within devolved competence. The committee considers this to be a fundamental constitutional principle. There are concurrent powers to amend rule in the European Union Withdrawal Act of 2018. In 2018, the UK Government gave a non-statutory commitment that it would not normally use these powers in areas of devolved competence, and not without the agreement of the relevant devolved administrations of the UK. So the committee will also be writing to Ms Badenoch to ask why a similar commitment has not been given with the retained EU law Revocation and Reform bill. And we note that there is also a lack of clarity into how common frameworks are operating, both generally and in relation to rule. There needs to be much greater transparency and accountability, and an opportunity for the committees of this Parliament to scrutinise both governments when decisions are being taken in devolved areas. So we invite the Scottish Government to provide us with detailed response on the effectiveness of the common frameworks, including how they are being used in relation to rule. And we extend the same invitation to the UK Government. My final theme relates to reporting requirements. For Scottish ministers, these should be, as a minimum, the equivalent to the requirements for UK ministers. Once the requirements are more settled, the committee shall invite our officials and those of the Scottish Government to look at how this can work in practice. That scrutiny of powers to restate, revoke, replace and update rule should not, in the committee's opinion, be conflated with the Scottish Government's policy to commitment to align with EU law. And, Presiding Officer, may I take an opportunity to thank the Parliament officials and those of the Scottish Government for all their work on this supplementary LCM. Time, Presiding Officer, has not been on our side, as the timescales on reporting on the LCM have been challenging, as also laid out by the Cabinet Secretary. And we note the commitment of the Scottish Government to provide further updates as required. Thank you, Presiding Officer.